Hello, my name is Sally Pinto, and I'm the Program Director for the Yonkers NORC, Neighborhood Naturally Occurring Retirement Community. We serve seniors 60 plus in Northeast Yonkers. We are under the auspices of WJCS and the Yonkers Office for the Aging. We also have a resource specialist and a nurse on staff. We conduct virtual programming in partnership with the Yonkers Public Library on a daily basis. Enjoy the program.
All of you. Today, we're going to be talking about protecting assets from the cost of long-term care. I'm just going to pull up my PowerPoint. We were making sure it worked before, so my apologies that we're not on the first page. And it's interesting. I was just talking with my partners about how, in terms of the economy right now, people's retirement accounts, brokerage accounts are all declining in value, at the same time that cost of living, be it food, gas, heating, everything is going up, and the cost of long-term care is no exception to the rule. And we talk about critical issues facing seniors, which is my first slide, and the biggest issue for many seniors is how to pay for long-term care and how to protect assets from the cost of long-term care. If people have questions, feel free to put the questions in the chat or unmute yourselves and ask the question. Nothing particular specific to you, but we could just talk about generalities. And I'll stay. Olivia will open the forum towards the end for questions as well. And critical issues facing seniors and protecting assets from the cost of long-term care. It's so important to be doing estate planning in terms of having a power of attorney, healthcare proxy, living will, a Medicaid trust, a revocable trust, a last will and testament, to really, again, start the conversation about estate planning, and then which also helps in terms of protecting assets from the cost of long-term care, and what does care itself cost. I always put this slide in because I found it to be a rather jarring slide. The cost of a nurse, and if we were in person, I'd ask you all to raise your hand and guess how much you think a nursing home costs. The average cost right now for a nursing home in Westchester County is about $182,000 a year. Home care runs anywhere from $70,000 to $80,000 a year. So if someone needs long-term care, be it in a nursing home or at home, they're going to drastically reduce their assets in order to be paying for such care. And so what we're going to really, again, talk about is how to start protecting some of those assets from the cost of long-term care and what options there are that are available. Whenever I talk about the cost of long-term care, I like to reference, there was a song in the, I think, 70s or 80s, if I had $1 million, I'd be rich. Right now, if you had $1 million in less than a couple of years, you wouldn't have those funds to be able to pay for your care, right? Because your savings are no longer generating the income that they were, last year, even 6 months ago. And again, our assets are dwindling right now as opposed to growing. And we really want to try to protect what we have and look at other means to pay for long-term care. So how do people pay for long-term care? Many people private pay, or they look to if they have a long-term care insurance policy, or they do Medicaid planning. And just as an explanation, Medicare will cover short-term rehabilitation in either a nursing home or rehab facility or at home. But that's skilled care, physical therapy, occupational therapy, speech therapy. When the person is no longer benefiting from those therapies, the Medicare coverage will end. And if a person remains in the nursing home, then either they're going to private pay for their nursing home care, or if they're in the community, private pay for their home care, use long-term care insurance to pay for that care, or look to become eligible for Medicaid, because as we said earlier, the cost of long-term care is prohibitive. So when we're talking about protecting assets from the cost of long-term care, The utmost and so important to do estate planning to make sure there's a power of attorney with broad gifting powers, a healthcare proxy, a living will, a burial designation form, having a last will and testament, perhaps having a revocable trust and or an irrevocable trust known as a Medicaid Asset Protection Trust. And I actually did a podcast a couple of weeks ago with a financial planner, and she said to me, Sarah, do I have to be rich to have a trust? And I always answer, no, you do not have to be rich to have a trust. You have to be done estate planning with the goal of being protecting assets from the cost of long-term care or protecting assets and avoiding probate. But trusts are not for the quote unquote, just for the quote unquote rich. It's very important to look when doing estate planning, if we want to do long-term care planning, the use of Medicaid Asset Protection Trust, also known as irrevocable trusts. And when I talk about with clients about doing their estate planning, I say, estate planning really has 4 key components, and we have 4 goals when we're talking about estate planning. One is preservation of assets, and to make sure there's enough assets for retirement, for long-term care and the like. Avoiding any estate tax, figuring out protecting assets from the cost of long-term care, and then upon passing, disposing assets to those who you wish those assets to go to. Right. So I think estate planning covers those 4 buckets. And it's important when we talk about long-term care planning and protecting assets from the cost of long-term care that we talk about estate planning first. And why a healthcare proxy? Right. If we're anticipating the need for long-term care, more likely than not, a person may no longer be able to make medical decisions for themselves. And you have a proxy, you sign a healthcare proxy appointing somebody to make those medical decisions for you. The only person who you can't have is your doctor. If your doctor is your treating physician, he or she may not be your healthcare proxy, and a person under the age of 18 can't be your healthcare proxy. A HIPAA form, and you probably sign these most times you go to the doctor, will allow the agent under your healthcare proxy to access your medical records. Especially, let's say you need to go see a specialist, to have your internist send the records over to the neurologist or obtain records from the emergency room or a hospital stay to give them to another doctor. So it's important to have that HIPAA form as well in terms of access to the medical records. And a living will, which is not a last will and testament. A living will is a document that says, God forbid, I'm in a vegetative or comatose state with no chance of recovery, what your end of life wishes are. Not to be put on a ventilator, not to have CPR, but not to have any tube feeding, but basically what your end of life wishes are as evidence to the agent under your healthcare proxy as to your end of life wishes. And the most important is a power of attorney. The power of attorney is a document where you're appointing somebody, an agent, to make financial decisions for you if you are unable to do so. So if you no longer have capacity or no longer able to handle your financial affairs, the agent under the power of attorney can step in your shoes and make financial decisions for you. Pay your bills, pay your taxes, create fund if the power of attorney allows for gifting, create a trust, fund a trust, add a beneficiary to a life insurance policy, to a retirement account, to a bank account. So again, a power of attorney is a very powerful document because it gives the agent that you are appointing legal authority to handle the financial affairs just as you would. So again, it's always very important to choose an individual whom you trust to handle your finances in terms of appointing the agent under the power of attorney. And going back to the healthcare proxy, it's important to appoint an agent to make medical decisions for you, not based on what that person would do, but rather what that person thinks the medical decision you would want to have been made. And we recommend a power of attorney that has very broad gifting and transfer of asset powers in terms of being able to do Medicaid planning, long-term care planning, in case you yourself haven't done so while you still had capacity, because there are always ways to protect assets from the cost of long-term care. But again, if a person doesn't have capacity and doesn't have a power of attorney with gifting powers, some of those avenues will not work as well. So again, very important to have a power of attorney with very broad gifting powers. General powers in a power of attorney is to handle real estate transactions, banking transactions, business transactions, estate matters, claims and litigation, paying your healthcare bills, but again, not making medical decisions for you, purchase and sales, tax matters. So again, very broad powers. And in the modification section is where we put in about allowing the agent to make gifts of assets, access a safe deposit box, create and fund a revocable and or irrevocable trust, to hire professionals to assist you, an accountant, an attorney, a geriatric care manager, to do a Medicaid application, to access your digital assets, your online assets, and even to do Medicaid planning by allowing you as a spouse to do something called a spousal refusal. So it's very, very important to have a broad-based power of attorney with broad gifting powers to really allow the agent to handle the all of your financial affairs as you would. And what about a will? A will is a document that says who you want to manage your estate, handle your estate, be the fiduciary or executor upon your passing, and who you wish to be the beneficiaries of your estate. And you can have provisions in there if a beneficiary is under a certain age, assets should stay in trust until that person reaches the age of 25, 30, 35. Who the trustee of that trust should be if there's a minor or a person under a certain age who's a beneficiary. Again, and who's the executor and or who the trustees should be. And I always put this slide in because people always ask, though I think we did a bit of a program with Yonkers in the spring about what happens when you pass without a will. The big misconception is that if you pass without a will, the government is going to take your money. That is not the case. If you pass without a will, the courts look to a statute which roadmaps the family tree as to who are the people, what are called the distributees, will inherit from your estate. But again, it's always much more important to have a will because then you can direct who the beneficiaries are, who the executor would be, if there are any terms or conditions that you would like. And talking about trust, as we talked about earlier, a revocable trust is a trust that you are both the grantor, the creator, and can also be the trustee. And the assets in the revocable trust are available to you during your lifetime. Those assets are still yours. The benefit of a revocable trust, if all of your assets are titled to the trust, is that upon your passing, those assets will pass to the beneficiaries named in the trust after all expenses have been paid, and you avoid probate. So that most people use a revocable living trust to avoid probate. We also use a revocable living trust in our asset as part of Medicaid planning or Medicaid, more Medicaid last minute planning. If a person is on Medicaid and owns their apartment, their condo, their co-op, and is receiving home care services during their lifetime, Medicaid cannot put a lien on that property because the Medicaid recipient or the Medicaid recipient spouse lives in that property. But if there's a Medicaid recipient who's receiving home care services, upon his or her death, there's no spouse living in the house, and that asset passes through probate, through the surrogate's court, either because there's a will or through the rules of intestacy, because the person owned the house or co-op or condo in their name alone. Medicaid can do estate recovery against that estate and seek to be paid back for the assets for the title, for the property when it's sold. To avoid Medicaid estate recovery of that property upon passing of the house, the co-op, the condo, if the co-op, the condo, the house is titled to a revocable trust, upon your passing, it avoids probate and estate administration, and Medicaid cannot place a lien on the property. So again, part of protecting assets from the cost of long-term care is making sure if a person is on Medicaid that they don't have a probate estate, their estate doesn't go to surrogate's court, and assets pass through, such as the house, pass through the trust to avoid Medicaid estate recovery. We also use an irrevocable trust, also known as a Medicaid Asset Protection Trust. So right now, as it's been since 2005, and prior to that, since I believe 1986, there used to be a 3-year look back for nursing home Medicaid. And back in 2005, it was extended to a 5-year look back for nursing home Medicaid. So if a person comes to my office, they are mostly healthy, but they don't have significant assets and want to start protecting them from the cost of long-term care, many times we will recommend that they retitle their house, their co-op, their condo to a Medicaid Asset Protection Trust, because after 5 years, that asset is fully protected from the cost of nursing home care. That person is on Medicaid. Then Governor Cuomo, I guess we should say, back in the 2020 budget, proposed a 2.5-year look back for home care Medicaid, which was supposed to go into effect in October of 2020. Due to the pandemic, that look back for home care Medicaid had continued to be extended. And right now it's anticipated that if a look back goes into effect for home care Medicaid, it will not start until January of 2024. So right now, still, there is no look back period for home care Medicaid, like there is for that 5-year look back for nursing home Medicaid. So we do this a lot. I actually just had a client come in the other day. Mom needs home care Medicaid. We are taking her house and deeding it to a Medicaid Asset Protection Trust, as well as her non-retirement assets. We're doing this all now in November. So December, she can be eligible for Medicaid and for Medicaid home care because the assets in that Medicaid Asset Protection Trust are protected for Medicaid home care purposes, because right now there's no transfer penalty for home care Medicaid. So now is a very good opportunity to start doing that Medicaid planning. And if it's anticipated, or if a person needs home care now, or they believe in the next few months, to start doing the Medicaid planning now, while there still is no look back for home care Medicaid. One of the downsides of funding the Medicaid Asset Protection Trust, and I think the biggest one, is where I'm healthy, though I want to start protecting my assets from the cost of long-term care. I know there's that 5-year look back for nursing home Medicaid, but I don't have any pre-existing conditions. Cognitively, I'm okay. But 2 years from now, 3 years with 3 years left on the 5-year look back, I have some kind of medical incident. I have a stroke, I break my hip, I need long-term care in a nursing home, I develop dementia. So one of the detriments while funding the Medicaid Asset Protection Trust is if I need Medicaid to pay for my nursing home care while I'm still in the 5-year look back. We have created what we call back doors into our Medicaid trust to allow return of the asset. But again, so we have a way around if we've triggered the 5-year look back for nursing home care, but now need care sooner rather than later. And let's talk about Medicaid for a couple of minutes. So Medicaid is a federal health insurance program run by the individual states, right? So our neighbor states are Connecticut and New Jersey. Though the New York Medicaid program is different from the New Jersey Medicaid program, which is different from the Connecticut Medicaid program. The programs all have to meet federal requirements, but can be broader. So for example, New York State has the most generous home care program, where New York will cover 24-hour home care services. It'll no longer cover what's called split shift, where you have one aide during the day and one aide at night, but it still covers what's called sleep-in care, where you have one aide who sleeps in your apartment, and here the aide, he or she, works usually 3 to 4 days a week, with then a second aide the other 3 to 4 days a week, and they're there 24 hours a day. So New York does have, believe the most generous home care program in the country. In order to qualify for Medicaid, you must be over the age of 65 or aged, blind, or disabled. You must be a U.S. citizen or a legal permanent resident, and then you also must reside for New York Medicaid in New York State. And here we're in Westchester County, and you reside in Westchester, you would apply for Medicaid in Westchester County. Medicaid does have income and asset rules. So for a single individual for this year, the Medicaid income limit is $934 a month, with the asset limit being $16,800. but your retirement assets, your 401k, your 403b, your pension are protected for Medicaid purposes, don't count towards that 16,800. The income limit is very low. In New York, we have a very generous program where if we're applying for Medicaid for home care services, we have something called the surplus income program. This for community Medicaid, but not for nursing home Medicaid. So to step back for a second, if I'm on Medicaid and in the nursing home, all of my income gets paid to the nursing home, though there's a little bit of budgeting. If my spouse doesn't have enough money, his or her income, I can give my income to that person to bring their income up to a minimum standard. And then the rest of my income gets paid to the nursing home. For home care and for community Medicaid, that income over $934 a month is known as surplus income. So if my income is $2,934, I have $2,000 more than the Medicaid income limit. So in most states, they would say, Sarah, you're not eligible because your income is too high. Here in New York, we have something called the surplus income program, wherein that $2,000 a month, I can be enrolled in something called a pooled trust. I take my $2,000, my surplus income, pay it to a pooled trust. These are trusts run by various nonprofits throughout the state. I then send my bills to the trust up to that amount, and the trust pays the bills from the monies I deposited into that account. So I'm not losing that $2,000 a month. I'm just using the pooled trust to protect that surplus income and then to pay bills. I know we're covering a lot of information in a short period of time. Any questions so far? Or is everybody doing okay? So it's important to note, I'll assume that everyone's following and enjoying lunch while we're meeting. So for home care Medicaid, as we said, we can use that surplus income, the income over the Medicaid income limit. We don't lose it, and we can be enrolled in a pooled trust and send the monies to the trust each month for the trust to pay our bills. And as we said, for nursing home Medicaid, if I have no spouse, all of my income gets paid to the nursing home, but I'm allowed what's called a $50 personal needs allowance, $50 in an account that the nursing home holds for getting my hair done, my nails done, my grooming, shaving, and whatnot. If there is a spouse in the community whose income is less than $3,435, and the spouse in the nursing home before having to pay the income to the nursing home, that income can get paid to the community spouse. So the community spouse has that minimum income amount of $3,435. So the budgeting gets very intricate, and it's so important to look towards protecting assets now, so income doesn't go to reduce income, protect assets in terms of being eligible for Medicaid to pay for that care and meeting the Medicaid income and asset criteria. Now, we said earlier, we'll go back to that slide, right? If I'm applying for Medicaid, my resource limit is $16,800. Now, there's something called spousal exempt transfers. So for home care or even for nursing home care, if I transfer assets to my spouse, that's considered an exempt transfer for Medicaid purposes. So if husband needs nursing home care and he has $200,000 of non-retirement money in his name, he can transfer those monies to his wife and for him to be eligible for Medicaid. So we talked earlier about having a broad power of attorney. When does that power of attorney come into place here? If husband no longer has capacity, how can we move assets from the husband's names to the wife's name to get him eligible for Medicaid? We use the broad power of attorney that allows for gifting to gift husband's assets over to wife. So again, all this why estate planning is so important, because there's so many facets or components to it, which are really with an eye towards protecting assets from the cost of long-term care. If there was no broad power of attorney, which allowed for gifting, or no power of attorney at all, and husband didn't have capacity, wife or if the family members or loved one or friend would have to bring a guardianship proceeding seeking to be appointed that individual's guardian in order to handle financial affairs and to seek court approval to move assets to a spouse to protect them from the cost of long-term care. So again, it goes back to why a power of attorney is so important. It's important in case a person, loses capacity and is unable to pay, his bills or her bills and handle his or her financial affairs, but also that broad power of attorney plays in to protecting assets from the cost of long-term care. Because if the person doesn't have the power of attorney or doesn't have a broad power of attorney that allows for gifting and doesn't have capacity, it's much harder to be able to move without court approval those assets from one spouse to the spouse not applying for Medicaid. Now, we just talked about the husband having about $200,000 in non-retirement monies and needing to move those monies over to his spouse to protect them from the cost of long-term care and to make him eligible for Medicaid. The Medicaid has a resource limit for the community spouse, and we have it on the chart prior. So the resource of a community spouse, Medicaid allows her to keep up to $137,400 this year, and that's known as the Community Spouse Resource Allowance. So if the community spouse has less than $134,000, she would not have to do what's called a spousal refusal. If she has more than that, that's above that CSRA, the Community Spouse Resource Allowance amount. And what happens then is because she's over that amount, then Medicaid would say, hey, husband's not eligible because you have more than the CSRA. So then the well spouse, the community spouse, has to do something called a spousal refusal. And it basically says, Medicaid, I'm not making my assets available to my spouse who needs Medicaid. I'm refusing to provide them. This is a provision is in what's the New York Social Services law where the Medicaid rules are found. So the community spouse says, no Medicaid, I'm not making my funds available to pay for my husband's nursing home care. You pay for it. So the spousal refusal then goes on file with the Medicaid application, and then Medicaid approves as long as the nursing home spouse meets the Medicaid income and resource criteria, approves that application. With the refusing spouse, though, as a caveat, because a New York State spouses are legally obligated to support one another, Medicaid can say, hey, refusing spouse, we're paying for your husband's nursing home care, pay us back. And so it's called, that allows Medicaid to do that. So you're now going to say to me, if we were in person, so Sarah, why would I do that spousal refusal? And I'll tell you why, right? All the way at the beginning, we talked about that slide where the nursing homes cost about $180,000 a year. So let's say the private pay rate at that nursing home is $16,000 a month. The Medicaid rate is closer to $7,000 or $8,000 a month. When Medicaid says to the refusing spouse, pay us back, that's at the Medicaid rate, so which is less than 50% of the private pay rate. So you're still paying a lot less for the nursing home care. So again, if you do have a spouse on Medicaid in a nursing home, it is important to look to Medicaid and doing that spousal refusal as opposed to having that full out-of-pocket cost of care. Now let's talk about, and we're going to see, I'll look at the other slide as well. Let's talk about home care Medicaid. So for nursing home Medicaid, we apply for Medicaid. We provide the 5 years worth of documentation. So Medicaid, look, we're financially eligible. We haven't made any transfers of assets. We're in the nursing home. Medicaid approves the care, pays the nursing home. Home care is a little different because first we have to apply for Medicaid, for community Medicaid or home care Medicaid, for Medicaid to review the application to make sure we are financially eligible. We meet the income and asset criteria. Only after Medicaid approves the application financially does Medicaid then do the home care evaluation. This has changed a bit this past year or two due to COVID and now to changes in the state budget. But what happens is this. First, Medicaid Department of Social Services does an evaluation to confirm that you actually are a person who should need home care services. Then another evaluation is done to determine the number of hours and the type of care that you need. You need 4 hours a day, 8 hours a day, 24 hours a day. And then Medicaid subcontracts out with Medicaid managed long-term care companies to implement the care plan and to put the hours in place. If you listen to the talk radio, at any AM dial, you'll hear about the Medicaid managed care companies. Your mom was living home alone, mom fell, we didn't know how to take care of mom, so we called such and such Medicaid managed care, and they came in, they did an evaluation, and are now paying for mom's care. So again, first we have to, the home care Medicaid process takes a lot longer, takes 5 to 6 months, right? Because first we have to be evaluated financially for Medicaid in terms of submitting the Medicaid application to demonstrate that we meet the financial criteria. And only after that application is processed, and that can take 2 or 3 months, do we go through the evaluation process for Medicaid home care to be put in place and to be implemented. So what will Medicaid home care pay for? They will pay for care as long as you need assistance with at least two or 3 activities of daily living: bathing, hygiene, using the bathroom, walking, dressing, toileting, mobility, eating, transferring. So you need actual physical assistance with at least 2 or now 3 of those activities of daily living. A Medicaid home attendant can't take care of any open wounds or sores. They can't deal with anything that is subject to an infection. It's really more helping you physically with those activities of daily living. And they also can't help you with bill pay or with grocery shopping. It's really helping you physically with those activities of daily living. One of the things I like about the Medicaid home care program is within the program, there's something called the Consumer Directed Care, or CDPAP. Instead of, once the home care Medicaid has been approved and the care plan assessed and determined, instead of using a home care agency to provide the care, other than your spouse, you can have a family member or friend be your home attendant. And especially during COVID, when children were moving back home and people were afraid of who was coming in and out of the house, people switched to the consumer directed model, and they hired and trained their own home attendants, so that for the most part, that was family members who were then residing in the house. Or if you've had a long-term friend or someone from the community or family member who was already informally helping you, they can be that consumer directed aid as well. And you're responsible for hiring and training and having backup, which you already have that relationship or want that family member doing it. And as we're seeing, I think we're going to see more now, if the economy continues on the trajectory it's on, more and more people are unfortunately, may lose their jobs. It may end up moving home, and then may end up being that consumer directed care as well. And so it's a family member or friend, as opposed to someone from an agency who would be your home attendant. Now this hadn't gone back into effect yet, so we're going to skip over that. When we were talking about nursing home Medicaid, I said that transfers between spouses are exempt. So if I needed nursing home care, I can transfer all of my non-retirement money, over $16,800, to my husband to have me then become eligible for Medicaid. To whom else can I transfer assets and it be an exempt transfer to not trigger that 5-year look back? Transfers to a blind or disabled child of mine of any age. The transfer of my house to a caretaker child. That's my child who's been living in my house for at least 2 years prior to my needing nursing home care. To my sibling who has an equity interest in the house. We inherited the house from mom and dad. My sibling and I own it 50-50. I need nursing home care. I can transfer my interest in that house to my sibling with the equity interest. Excuse me. I'm sorry. What are some non-exempt transfers? Transfers for less than fair market value. My house needs to be painted, so I pay my daughter $50,000 to paint the house. We all know it does not cost $50,000 to paint the outside of the house. So the gift over the fair market value, my apologies. I'm sorry, my office is very cold. So let's say it only costs 4,000, anything above the 4,000 is not fair market value, and that's considered a gift. And just gifts I make to family members, friends, and others for purposes of qualifying for Medicaid are non-exempt transfers. However, let's say I've paid for all of my grandchildren's college education. I have 4 grandchildren, and over the past 15 years, I've been paying for each grandchild their college tuition. And there are 2 grandkids who I paid for their tuition within the 5 years of needing nursing home care. We can demonstrate to Medicaid, hi, grandma has a history of paying all the grandkids' tuition. The tuition was not paid to qualify for Medicaid, but rather for purposes other than qualifying for Medicaid. And Medicaid, therefore, these are exempt transfers and don't count towards the 5-year look back. Now, a Medicaid crisis plan. Now, all of us here in our Zoom room are going to be protecting assets and doing our estate planning and long-term planning because we know the importance of it and we know how much long-term care costs, and we want to start protecting our assets from the cost of long-term care. Unfortunately, there are people who decide not to do any planning or don't do planning or think just don't plan, or unfortunately don't know the benefits of doing that estate planning and long-term care planning. And this happens all the time. I'll get a call, Sarah, mom fell, she needs nursing home care and she has $300,000. What do we do about it? And we can do something called a Medicaid crisis plan. This is for a person who needs Medicaid in a crisis mode for nursing home care, who doesn't have a spouse to whom they can transfer assets, or that disabled child to whom they can transfer assets. And what a Medicaid crisis plan does is we can protect about 40 to 50% of the person's assets from the cost of long-term care. So we know if we gift assets for Medicaid purposes, that starts the 5-year look back and triggers the penalty period. Meaning, let's say I transfer a gift $100,000 and I need Medicaid within the 5 years. Medicaid will see that I gifted $100,000 and they'll deny my application and say, Sarah gifted $100,000. For roughly every $10,000 gifted is a 1-month period of ineligibility for Medicaid to pay for nursing home care. So Medicaid will say, okay, we're denying it now, but in 10 months, we will then approve you for Medicaid because after you're outside that 10-month penalty period. So let's say I have $200,000 and I need Medicaid to pay for my nursing home care now. We know if I gift $200,000, that'll be about a 20-month period that Medicaid won't pay for my nursing home care, but how is that care going to be paid for? So the option, or the other option, is just take my $200,000 and spend down till I have none left and then apply for Medicaid. But in that respect, I haven't been able to gift any assets or protect any of my assets from the cost of long-term care. So I can do something called a Medicaid crisis plan, wherein I can gift of my $200,000, $100,000 to my kids or someone of my choosing, and knowing that will trigger the 10-month period of ineligibility. The same time I gift the $100,000, I loan that person $100,000. And that loan then is used over those 10 months where I'm not eligible for Medicaid to pay for my nursing home care. So again, we're not able to protect 100% of the cost of the assets from the cost of long-term care because we didn't do that advanced planning, but at least we're protecting about 50% of the assets from the cost of long-term care. We're in crisis mode, so again, we can't protect everything, but we can at least protect 40 to 50% of it. Okay, what are our key takeaways? And then we'll open this up for questions. The key takeaway for me is planning, planning, planning. It is so important to do the estate and long-term care planning, to have a broad power of attorney that allows for gifting in case we're in crisis mode and the person doesn't have capacity, to transfer assets into a Medicaid asset protection trust, start the 5-year look back, to start protecting some assets from the cost of long-term care. Have a power of attorney, have the healthcare proxy, create a revocable trust for ease of management. Also, what's another key takeaway that I talk about in others, but let's talk about it here. Make sure somebody knows where all your documents are. make sure that somebody whom you trust knows that in the bedroom or in the den, in the top, in the top drawer are copies of all of your documents with your attorney's business card, with your accountant's business card, with a list of the assets. So if we are, God forbid, in crisis mode, somebody knows where to look for all of your information. And again, it's so important to do that planning to start protecting assets from the cost of long-term care, because as we said, long-term care is very expensive. Everything right now is very expensive. Everybody, your assets are not as, have their balances have decreased right now. And it's so important to take the assets that we have to start protecting them from the cost of long-term care. Any questions for me? And I'm going to just stop sharing so I can actually see if someone has a raised hand or a question. Any questions?
There was a question, and it was back in a few slides. What does that look like with a joint account, the transfer from one spouse to another?
Okay, Sally, that's an excellent question. So if Sally and I have assets in a joint bank account, we're each entitled, so pursuant to the banking law, we each own 100% of those assets. For Medicaid purposes, for non-spouses, Medicaid assumes that the assets in that account are all owned by the Medicaid applicant unless you can prove otherwise. In terms of of husband and wife, if wife needs nursing home care and husband's in the community, either you just take wife's name off that account or reduce the balance in that account to below the Medicaid asset limit. Any other questions? I didn't see any in the chat, but when I find that when I have the PowerPoint up, it's harder to see the chat.
There's none in the chat, but I have a question. So
Sure.
Let's say a couple is 55 and 59. At what point should they decide to start looking into, and they're, they have the documents together and whatnot. At what point do they decide to buy the long-term care?
So I don't sell long-term. I'm just an attorney. I don't sell long-term care insurance. I think it's a very personal decision. There comes a time. So if you talk to someone who sells, an agent who sells long-term care insurance, they'll tell you that sweet spot is usually from about 55 to 65, because once a person has a pre-existing condition, they can be harder to insure. I know it's for life insurance, but on the radio, I'm Big Lou and I'm on meds too, or I'm Big Lou and I have a second wife too. I love Big Lou. He has these great commercials, but part of that also is you're harder to insure the older you are if there is a pre-existing condition, and the higher the premiums may be. So most will tell you that sweet spot is really like 55 to 65. But again, if you are interested in long-term care insurance, I would start making those inquiries now. Any other questions? And I'll just to also play off on what Sally was asking. A lot of people don't buy long-term care insurance because it's very expensive, which is why doing long-term care planning and Medicaid asset protection planning can accomplish many of those same goals in terms of protecting assets from the cost of long-term care. I do know a lot of people have started purchasing the hybrid policies, which is long-term care with a life insurance component or life insurance with a long-term care component. So that way, if thank God you never need long-term care, upon passing, the policy converts to a life insurance policy. So that's something also very important to look into when deciding to purchase long-term care insurance. Is it a hybrid policy? So please God, I won't have to use it. Can then there be a death benefit as well? Any other questions, comments, or concerns?
I know Sarah was very detailed, but if you have any questions, this would be a great time to ask. You can either put it in the chat, or I believe you can unmute and ask a question. The other question I have also, Sarah, is you're very detailed in this presentation. Thank you. How long does this process of getting long-term care insurance and getting all these documents, how long is this process usually?
Okay, so again, we don't sell long-term care insurance.
Sorry about that.
I think that's working with an agent in terms of, I know their evaluations, there's whatnot that needs to get done. That probably takes about 3 to 6 months. In terms of Medicaid and long-term care, asset protection planning, the estate planning, If a person I could talk about our office, a person would come in, we'd sit down, go over the family, get to know each other a little bit, go over what a person's goals are. Is it estate planning? Is it Medicaid planning? Is it a bit of both, making sure their kids, their grandkids inherit the assets that they have? We'll go through their income and assets. We actually ask if there's any medical condition a person has, any disabled child or grandchild. We'll come up with a plan, be retained, draft the documents, and that just takes about 6 to 8 weeks. So it's a pretty quick process once we're retained to do that estate planning.
I have a question. The HIPAA form, is that a New York form? Because you fill out HIPAA forms every time you go to a doctor's office. So is this like one big global form that overrides the ones that you do at a doctor's office?
So HIPAA is federal legislation, the Health Insurance Portability and Accountability Act of 1996.
Right.
One of the provisions is, the big thing is to make sure that the patients have the right to privacy. So all that HIPAA form does, that I know my office prepares, many attorneys and doctors have them too. You're basically appointing somebody to be able to access your medical records.
Right. So what you're saying though is that you fill out that one HIPAA form along with your power of attorney with you if you were doing that work. So does that override all of the HIPAA forms that you filled out at the doctor's office? Because often when you go, they have you fill out a form when you're there.
Right. So the HIPAA form does not revoke all prior HIPAA forms unless you wanted to. Like a power of attorney revokes all prior powers of attorney.
Got it. Okay. All right. Thanks.
You're welcome. Any other questions? So Sally, thank you again for inviting me to come into everybody's living rooms. I hope the program was helpful. Always feel free. Sally has my contact information. Again, my name's Sarah Myers. I'm an attorney with the law firm of Ania, Scanlon, and Sirignano. We're in downtown White Plains. The phone number is 914-948-1500. I think there was a question about the average cost for various trusts. I think what we can do, estate planning really depends, and estate planning people might think is cookie cutter, but it's actually not. And if I do planning for Z, for Sally, and Alexis, they think they're all going to come out with the same documents, but they're all each going to come out with documents that are specific and tailored to them, and people's circumstances are different. So I can tell you the range in Westchester, in general, estate planning can cost $2,500 or can cost $8,500 depending on the planning that needs to be done.
Hi everyone, this is Z from Yonkers Public Library. Thanks so much to Sally Pinto and Alexis from Newark. Thank you to our community partners, WJCS, the City of Yonkers Office for the Aging, Friends of Crestwood Library, and Yonkers Public Library for making this phenomenal partnership. And we thank each and every one of you for being part of our wellness community. Be well, stay well.